Good morning. Happy Wednesday. We're going to go over Pink Camera Magic's lawsuit that was dismissed. This is the memorandum of opinion and order dismissing her lawsuit. And we're not going to go over everything word for word, but we're going to go over what I think are the important parts. So she's at a courthouse that does domestic violence and felony matters in traffic court. And victims, witnesses, and jurors all use the front entrance. She went there to address 3 traffic tickets. She had a Sony handheld camera in her purse. A sheriff's deputy denied her entrance because she had the camera. She was advised to call the sheriff's office to see if they would hold her camera. She stepped outside to call them, and they said, no, we're not going to hold your camera. So she then stood out in front, and she began filming. And she asserts she was recording her reflection in the mirrored windows. And the defendants say that her recording captured people going in and out. It captured the entranceway, the security features, including the positioning of security personnel, locations of metal detectors, surveillance cameras, emergency exits, panic buttons, call boxes, and vehicular barriers. And so this guy, Barbero, he sees her recording, goes outside, and he's concerned because she can record his security stuff. And so he goes outside to see what she's doing. She says that, or she doesn't respond, I should say. And then, so they testify that anybody recording from where she was would be able to see inside and videotape inside the building. That's not what the film showed, but whatever. So they radioed for additional security and a supervisor, and then Milazzo showed up, and they told him what's going on, and Milazzo thought it was suspicious. Now, Milazzo approached plaintiff and asked her, and told her that there's a court order that says you can't videotape the building. And she asked him if she could see it. He said, yeah, come on in. We're going to check your IDs too. She said, oh, no, I'm not going in. He's like, no, we're going to run you too. We're going to get your name. We're going to do a report. She said, no. And that's when Milazzo told Pink that he was detaining her because she was doing something suspicious. He told her to come in. She said, I'm just going to stay right here and continue recording. And then he said, you're going to come in and we're going to find out who you are and what you're doing. So then she expresses incredulity and be detained for taking pictures of the building. He says, you're doing something suspicious. We need to know who you are and why you're doing it. Okay. She then asked him if he was familiar with the First Amendment, and then the arrest happened. Well, I'm going to call it the arrest. Everywhere in here, both parties, the defendants and the plaintiff, all refer to this as a detention. I think that is important. For legal analysis later, whether or not an arrest occurred, I think an arrest did, but we'll get there. So the officers escorted her into the courthouse, and they asked her to identify herself. And they said that they weren't going to let her leave until she identified herself. At this point, finally, Pink Camera Magic says, I want to remain silent and I want a lawyer. Phenomenal. She should have said, I want to remain silent from the get-go, but that's just me being a lawyer. She refused to consent to the search or seizure of her camera and asked Milazzo if he'd heard of the Fourth Amendment. He said, oh, great. Why do we always get the crazies? Yeah, it's real crazy to ask if someone has heard of the Fourth Amendment. After this statement, the video footage from plaintiff's video ends. So Milazzo testified that she remained detained. He contacted his supervisor, who instructed him to contact the presiding judge for further instruction. And then he called the judge's office, and they told him to bring the plaintiff to Judge Peter Felice. At some point, Milazzo emptied the contents of plaintiff's purse on a counter and searched her wallet until he found her identification. Milazzo also searched through the contents of plaintiff's camera. Now, the search of the wallet, I think, would be 100% justified if she was arrested at this point. And I find it squirrely, and I think in a criminal case, this is a civil case. I think in a criminal case, if he had found something, she would have an excellent argument to suppress it because he did not have probable cause to search the wallet, and he had not arrested her at that point. You can't say, at least in my criminal experience, which is fairly slim, I would certainly be drafting a 1538.5 motion to suppress this evidence because she was detained, and the officer thought she was detained at this point. The officer had not arrested her. And so he's doing a search incident to lawful arrest in the wallet, and he should not. He should not. If it is a detention, you're limited to a Terry frisk, which is where you get to pat the outer, surfaces, check to see if there's something in there without doing an invasive search. But he searched her wallet, which is pretty invasive. And then he also searched the contents of her camera. Now, that's a little bit more questionable than the wallet even. Because it is an electronic device and it may contain things on there that, are more of a personal nature, like a cell phone would. But it is a camera, not a cell phone, and we'll get there in the analysis. The parties dispute how long she was detained. Again, the parties are both in agreement that she was detained. Plaintiff states she was in the deputy's office for an hour and a half while handcuffed. Defendants dispute the statement, but do not offer their own length of detention. So they escorted her in front of a judge, Judge Peter Felice. They have not offered her an attorney, even though she has requested one. They have not done anything to give her any of her rights to prepare for trial or anything like that. I mean, this is basically going to be an arraignment, a trial, and a sentencing all in the same day. So, the court says what was observed. What was this woman doing? And then Malaza says she was observed videotaping in front of the building when the doors had opened, trying to videotape inside the doors. When we asked her what she was doing and why, she refused to identify herself, refused to explain what she was doing, wouldn't tell us anything until we took her in to detain to find out who she was. Court says, can you tell this court for what reason you're videotaping this facility and the people walking in and out? She says, that's not true, I wasn't. Court says, well, maybe he means there are people walking in and out of the front door, am I correct? And then Pink says, well, that happened. I have business here. I have court at 1:30 for some traffic stuff. So I was getting ready to leave out, go outside, killing some time. And there's a reflection. I wasn't recording a door. I was outside the whole time recording the reflective glass. I was recording my own reflection. The court said, why? She said, just because I record and it's a hobby. I've told people a lot, and no one ever seems to believe me that all this nonsense about, I just record because I want to record. I'm just recording the signs in the lobby. I'm just doing, all these things nobody believes. And the court certainly doesn't believe. And the cops don't believe. Nobody believes it. I mean, it makes you sound like a liar. It literally makes you sound like a liar when you say that. So, I'm not your attorney, but if I was your attorney, I would recommend that you just exercise your right to remain silent from the get-go and never make up stupid reasons for doing things. Let the state have to prove your intentions instead of you giving them nonsense. But again, I'm not your attorney. Judge Felice then informed plaintiff that there's a standing order that no photography should take place inside the courtroom, and that's going to include the entrance and the exits. He also instructed plaintiff not to record this building, people coming in and out, or anybody in the parking lot. He then gave her the option to surrender her camera's SD card for staff to erase, or just surrender the SD card completely. She chose to have the staff erase it, and then when she picked it up, she had it restored by a specialist. So she sued. And let's get down through here till we get into the analysis of her case. The court proceeds chronologically, starting with the initial stop of plaintiff as she filmed the courthouse from the outside. On this issue, plaintiff argues that Barbero's initial stop violated her Fourth Amendment right to be free from detention absent reasonable suspicion, while defendants argue that Barbero possessed reasonable suspicion to conduct a Terry stop. Now, I want to just stop there and remind everybody that there is almost no way, unless the cops are retard, for them to not have reasonable suspicion. Because if the cops suspect something, there is a reason for it. If you suspect your husband is cheating on you, then there's a reason for it. And you could You could, if you took the time, point to things like he's coming home late from work and he's not showing overtime on his time cards. He gives evasive answers when I ask where he is. I saw lipstick on his shirt collar. You can there are things, some facts are giving you suspicion. And all the cop has to do is recount those facts. Those facts can be really, really stupid. There are very few facts that will not lead to reasonable suspicion. Very few. Like the biggest one is you can't just say, well, because the defendant was black, so I suspected him of being a criminal. That's not the all, but I mean it's basically down to that point. The cop has to be basing his suspicion on like race or gender or sex or whatever, color of the skin. I mean, he has to be doing it on a protected characteristic, or he has to be really stupid and not to get reasonable suspicion. It's really hard to say that a cop doesn't have reasonable suspicion. It's generally going to be a losing argument because it is so hard to not have reasonable suspicion. You got to remember that Terry walked up to a window, a store window that had a display inside of it. He was literally window shopping. He walked up to a window a couple dozen times and walked away from it to talk to his friend. And that was enough to give Officer McFadden reasonable suspicion. It's a very low bar. Given the factual record, defendant's theory prevails. Who could have seen that coming, right? Clearly, videotaping other people when accompanied by other suspicious circumstances may constitute disorderly conduct. He's quoting Reher v. Vivo, which is a federal court, a federal decision, quoting a statute. Under an Illinois statute saying that a person commits disorderly conduct when they knowingly do any act in such unreasonable manner as to alarm or disturb another and provoke a breach of the peace. Which, okay, I guess. In this case, Officer Barbero testified he observed plaintiff scanning back and forth with the camera, up and down, people coming in and out, possibly videotaping through the glass at the security post that I work at of the entry procedure. According to Officer Barbero, the courthouse installed cameras outside the building after the 9/11 attacks to watch the intakes for the air system in case someone wants to do something with that. Given such circumstance, 9/11, oh, pink camera magic, God bless her, but she's not crawling in through an air intake system. She's not. I guarantee you she is never going to crawl in through an air intake system. But 9/11, folks. Given such circumstances, Officer Barbero had reasonable suspicion to believe that the plaintiff violated or was violating a general administrative order of the court. And then the order that was in place in March 2018 provides, except as noted below, all mobile computing and telecommunications devices, including but not limited to cellular telephones, smartphones, laptop and tablet computers, and other electronic devices capable of connecting to the internet or making audio or video recordings are prohibited in the Circuit Court of Cook County, Illinois. So for those of you who think that courts can't do this, you're seeing precisely here and now that courts can. And or the Illinois statute prohibiting disorderly conduct. So just so you know, it's not the recording itself that would violate the statute. A person commits disorderly conduct when they knowingly do any such act in such an unreasonable manner as to alarm or disturb another and to provoke a breach of the peace. So reasonable suspicion that they may be doing something in an unreasonable manner, like, I don't know, recording your reflection in the glass of a courthouse might actually work there. Are you just trying to irritate people or scare people? Like, what are you doing? Reasonable suspicion. You're doing something and you can't give a good accounting for why you're doing it. He saw the plaintiff filming the entrance of the courthouse, a place where jurors, victims, witnesses, and litigants appear, and where security measures remain in place for the protection of all who come within the courthouse, including jurors, victims, witnesses, litigants, attorneys, and courthouse security officers and judges. And the court also finds Officer Barbero's decision to radio for a supervisor and Officer Malazzo's subsequent investigatory stop of plaintiff outside of the courthouse reasonable under the circumstances. Officer Barbero came out and asked plaintiff what she was doing, to which plaintiff responded that she was recording the building because she simply wanted to record it. Plaintiff ignored Officer Barbero's questions about the purpose of the recording. So she gave an answer. If she had not given an answer, that might be different. If she had just stated something along the lines of, I'm invoking my Fifth Amendment right, I'm asserting my right to remain silent, I'm taking the Fifth. If she had done something like that and then shut her pie hole, this might have gone a little bit different. And I'm sure her attorney probably said the same thing to her. Any reasonable officer would become concerned about plaintiff's intentions for recording it and would continue to investigate and call for backup. As Seventh Circuit recognized in Braun v. Baldwin, courthouses are potentially dangerous places because of the presence of criminal defendants, bitterly divorcing spouses, and custody contesting ex-spouses, and other highly stressed, emotionally excited, and even violence-prone litigants. And thus, police and guards are entitled to exercise a degree of control that would be oppressive in a different setting. Okay. So they're quoting from Newell v. County of San Diego, holding that a reasonable officer in charge of courthouse security who had just observed an individual taking photographs of one or more courthouse employees and or law enforcement vehicles parked in the private portion of the courthouse parking lot would, at a minimum, contact the individual to ascertain his or her intentions, and this case noting that the governmental interest in safeguarding courthouses is paramount. In Katie versus Sheehan, the Seventh Circuit held an officer was entitled to conduct a Terry stop of an individual who was lurking amongst the bushes. She was not lurking amongst bushes, but okay. Outside a courthouse for 2 hours before it opens. The courthouse was open here, but okay. Is shabbily dressed. I don't know how she was dressed that day. Carrying a briefcase. Claims to be a federal process server, refuses to provide identification upon request, and is evasive in response to police questioning. As the court reasoned, a reasonably prudent officer would be concerned. Oh, and I just want to point this out again. So, being evasive in response to police questioning means that questions were being answered evasively. If this person who claimed to be a federal process server had shut his pie hole, the court cannot use a Fifth Amendment, they cannot take you exercising your Fifth Amendment right to remain silent against you, because they can't do it. But if you answer evasively, the court can look at your evasive answers and use that against you, which is why lawyers time and time again will tell you to shut the F up. As the court reasoned, a reasonably prudent officer would be concerned for the safety of officers and civilians in the areas as well as for the stopped individual. Here, as in Cody, a reasonably prudent officer in Officer Barbero's position would be concerned about the well-being of officers, jurors, witnesses, victims, and judicial employees after seeing plaintiff videotape the courthouse and refusing to answer basic questions, especially where, as here, reasonable cause existed to believe plaintiff captured footage of the court entrance and the inside of the courthouse, including the security post itself. Plaintiff counters that she was only filming her own reflection off the outside of the building. But a reasonable courthouse security officer would have no way of knowing that at the time. Behavior which is susceptible to an innocent explanation when isolated from context may still give rise to a reasonable suspicion when considered in the light of all the factors at play. Now, you may be thinking that the court is actually giving a little bit of credence to plaintiff's contention that she was only filming her own reflection. But since he is granting the defendant's motion to dismiss and denying plaintiff's motion to dismiss, he is taking all the uncontested facts and he is construing the facts that plaintiffs assert. He's construing the facts in the best light for the plaintiff, which is her. And even with the facts being construed, even if the jury believed, is what he's saying, even if the jury believed that plaintiff was filming her own reflection out off the outside of the building, even if the jury believed that, still as a matter of law, the defendants would win. Do not believe for a second that that the court thought that plaintiff was just filming her own reflection. The court knows what she was doing, but this is just as a matter of law, in order to grant the defendant's motion to dismiss, they have to construe all the contested facts in the light most favorable to the plaintiff, who is having her case dismissed. Dorosiak testified that someone standing at her distance could see inside the building and videotape the security stuff, and he thought that she was possibly videotaping the security stuff. And the video footage itself confirms that plaintiff did, in fact, record both the exterior and interior of the courthouse. And given the heightened security concerns surrounding courthouses, a reasonable officer in his position would, at a minimum, stop plaintiff to investigate further. Parties also agree whether his radioing of Malazzo's subsequent questioning and detention of plaintiff outside and inside the courthouse amounted to an unconstitutional Fourth Amendment seizure. On this issue, plaintiff contends that once Malazzo handcuffed her and led her into the courthouse, the action escalated the initial Terry stop into a de facto arrest, which she argues was unsupported by probable cause. I would argue that maybe not when he just took her inside the building. That could have been for convenience. That's like placing a suspect inside a patrol car. It doesn't, or driving a potential suspect past a victim. They do that sometimes. They'll put the suspect in the patrol car and they'll take him to the victim so the victim can see him and identify him. That doesn't mean that you've been arrested. But I would argue taking her in front of the judge, that meant she was arrested. You don't get hauled by the police in front of a judge unless you're arrested, in my humble opinion. Defendants, on the other hand, maintained plaintiff's continued detention remained within the scope of a permissible Terry stop and did not ripen into arrest. So the defendants say that it's not an arrest. And, okay. This view, so why could they search her? I just don't get this. Why could they search her if they don't think that she's arrested? No, we're not arresting her, but we're going to do a search incident to lawful arrest. Blows my mind. Sorry, I'm going to continue. This view finds support in the record because plaintiff's evasiveness, again, if she just shut up, and refusal to identify, if she'd shut up, she's not refusing to identify. She's not talking. If she'd invoked her fifth and shut up, and they're like, what's your name? She's already invoked her fifth. They can't construe her silence against her. That's why we tell you. Sorry. The Supreme Court has explained that obtaining the suspect's name in the course of a Terry stop serves important governmental interests. And knowledge of identity may inform an officer that a suspect is wanted for another offense or has a record of violence or mental disorder, or may help clear a suspect and allow the police to concentrate their efforts elsewhere. That was Hibble. But you also have to remember that in Hibble, Nevada had a statute that said if the officers detain you, they can demand your ID. And if you refuse to give it, that's a misdemeanor. So then they could arrest you for failing to ID, and they could search you for the ID at that point without any issue. But you see how that's different than what's going on here. I don't know that Chicago has some sort of a statute on the book saying that they could actually search you if they've seized you, if they've detained you on a Terry stop. I don't know if there is a statute that authorizes them to demand your ID. They obviously didn't charge her with failing to ID, so I don't know. But unless there's some sort of a statute authorizing them to demand ID and criminalizing it if you don't give it, then I don't know why he's quoting Hibble. And see also Gallegos versus City of Los Angeles, holding that an hour-long investigatory detention after placing plaintiff in handcuffs at gunpoint was reasonable to investigate whether he was the subject of a 911 call, because the whole point of an investigatory stop, as the name suggests, is to allow police to investigate, in this case to make sure they had the right person. Yeah, so to make sure they had the right person, they knew they had the right person. They knew they had pink camera magic. They knew that she was the one recording. They're fishing for something else. Anyway, while relevant facts remain in dispute regarding the scope of detention, such factual questions remain irrelevant here because even if the initial stop ripened into an arrest, the officers possessed probable cause. Based on the record, a reasonable officer had probable cause to believe that plaintiff violated the general administrative order prohibiting filming inside the courthouse, as well as the Illinois statute prohibiting disorderly conduct. Now, I agree with the court that on the former. I agree that there was probable cause that she'd violated the order. Now, I think they had reasonable suspicion that she violated the Illinois statute prohibiting disorderly conduct, but I don't believe that they had probable cause for it. But your mileage may vary. They had at least probable cause for one thing. I agree with the court that they had probable cause for the order filming the inside of the courthouse. Your mileage may vary. Moreover, by the time Milazzo ordered the other officers to handcuff plaintiff, the officer's initial observation combined with plaintiff's evasive answers to routine questions about her identity and intentions, and then there's a period there. I don't know what he was intending to say. That is a sentence fragment. It happens. It happens to the best of us. Given the totality of the facts available to the officers who viewed plaintiff's behavior as well as her own evasiveness and lack of cooperation, you don't have to cooperate with the police, but if you're giving evasive answers, that makes you uncooperative. It's different. A reasonably prudent person in the officer's position would think that plaintiff had committed or was committing a crime. Again, she should have just shut the F up. It doesn't make good videos, I guess. So I guess that's the problem. It doesn't make good videos. If an officer has probable cause to believe that an individual has committed even a very minor criminal offense in his presence, he may, without violating the Fourth Amendment, arrest the offender. Accordingly, this court finds that reasonable suspicion justified plaintiff's initial stop and probable cause supported her later arrest. But then there's qualified immunity, and she loses on qualified immunity. But this is the fun part. Again, more fun part, I should say. Search of the plaintiff's belongings. This court separately analyzes plaintiff's claims based on the constitutionality of the officer's searches of her purse and the contents of her camera. The undisputed record shows that at some point, while the officers held plaintiff in the courthouse, Milazzo emptied the contents of plaintiff's purse on a counter and searched her wallet until he found her identification. Milazzo also searched the contents of her camera. Plaintiff challenges the constitutionality of these searches. Warrantless searches are yada, yada, yada. Applying these standards, the seizures and searches of plaintiff's purse and wallet fall plainly within the scope of search incident to lawful arrest exception, because plaintiff exercised immediate control over her purse. Now, again, I think while it did turn into an arrest, when the officer was searching her purse, even up through and during what I think was technically an arrest, the officer did not believe that she was arrested. So this seems like a little bit of jiggery-pokery to try to shoehorn a search incident to a lawful arrest when the officer didn't believe he had arrested her. I have a bit of a problem with that, but the court didn't. So she loses on the search of the person and wallet because it would be a search incident to a lawful arrest. Likewise, plaintiff fails in her challenge of Milazzo's search of the contents of the camera. She cites Riley versus California, where the Supreme Court held the warrantless search of a cell phone is not a permissible search incident to arrest. And the court reasoned that modern cell phones have immense storage capacity and collect many distinct types of information, an address, a note, a prescription, a bank statement, a video, that will reveal much more in combination than any isolated proof, and thus trigger privacy concerns. In other words, cell phones contain a digital record of nearly every aspect of a person's life. Now, I like to think that it shouldn't be just because cell phones have so much information that they should have protection from being searched without a warrant. I think it should be because once the officer has the device in their possession and outside of the possession of the defendant in a criminal matter, then there's no rush. There's no need to not get a warrant. Even if you just had an envelope, let's say you had an envelope, like mail, an envelope that was sealed, like, let's even say like it had a stamp on it, it had an address from and to. If you got arrested, could the officer open up that letter right then and there? Maybe, probably, but should he? Like once they've taken it outside of your possession, why should I? So I understand that inventory searches are a thing. I understand it. I understand that the courts have reasoned that the cops can inventory vehicles and things. It's for administrative purposes, so we get to search it. Fuck the Fourth Amendment because it's for inventory searches. Excuse my French. But I don't buy that. Personally, I think we've degraded the Fourth Amendment beyond recognition by allowing these exceptions to the warrant requirement that aren't based on exigency. Like if someone says there's a bomb in that car and it's got 5 minutes before it goes off, yeah, open up the car, search the car, find the bomb. Disarm the bomb. I don't have a problem with that. But if it's just something that, it's going to sit here until you get a warrant, get a warrant. I mean, that's why they put that. They didn't put exceptions in the Fourth Amendment. And so I disagree with the court reading exceptions in. And I don't care that it makes things easier for the cops. It's not supposed to be easy for the cops. It's supposed to be hard for the cops for a reason. And that's to protect innocent people from abuses by the police. And the more exceptions that we make, I'm getting on my soapbox and I'll get off in a second, but the more exceptions that we make for the convenience of the police, the more abuses that we've seen. Relying on Riley, plaintiff argues that the video camera is sufficiently analogous to cell phones that the Supreme Court categorically held required warrants to search. But, as the California District Court explained, Riley limited its holding to cell phones and left the law with regard to cameras unsettled. That's your boy, American News and Information Services Incorporated versus Gore. God, what was his name? J.C. Playford. Boy. If you go in to a case on bad facts, you're very likely to get bad law made as a result. And J.C. Playford got some bad law made as a result. Thank you, J.C. Playford, for screwing the pooch and making it harder for everybody else. Phones are both similar to and different from cameras. Like cell phones, cameras typically lack the potential to be used as a weapon, have significant storage capacity, and potentially can reconstruct an individual's private life through date-stamped photographs. Unlike cell phones, however, cameras do not contain phone call logs, text messages, applications, hobbies, budgets, or a digital record of nearly every aspect of the individual's life. In this case, the court doesn't need to conclude it because even if they did, the qualified immunity would kick in. And then First Amendment retaliation claims. She claims that the cops were retaliating based on her exercising her First Amendment right. And Neves v. Bartlett, that was a recent Supreme Court case, 2019, where the cops had probable cause to arrest somebody, and I don't even think they arrested him. Didn't they detain him in Neves? Maybe they did arrest him, but he didn't get charged. That's what it was. Anyway, so if they have probable cause to arrest you for anything, they can arrest you. And it doesn't matter if they wouldn't have arrested you if you weren't exercising your First Amendment right. As long as they had probable cause to arrest you, they can arrest you. And now, again, the officers didn't think they arrested her. But, okay. But the court says that based on Neves, because the officers had probable cause to arrest her, then she loses on the retaliation for the arrest. And then Monell, etc. But at the end of it, they denied her motion for summary judgment, and they granted the defendant's motion for dismissal on all counts. So there you go. Hope this was informative. If anything, if you could learn anything from this, I would hope that you learn a few basic things. Number one, reasonable suspicion is almost impossible. It's almost impossible for a court to find there is no reasonable suspicion. You have to have a very stupid cop in order for the cop not to be able to come up with reasonable suspicion. It's very rare that they can't. That's number one. Number two is courts can and do enforce no filming. And I have not found any case ever that says a court can't control filming inside of the courthouse. Even outside of the courthouse on court grounds, here as in this case. I mean, so you have to understand, whether you agree with it or not, whether you think it violates your First Amendment right or not, you have to understand that that is the current state of the law. Number three that you should learn is, I should have put this number one because it's the most important thing. Don't talk to the police. Do not, under any circumstances, talk to the police. Assert your right to remain silent and then shut up. Because by continuing to talk, you give them the ability to argue that you are being evasive and uncooperative. If you just shut up, they can't say anything about you not cooperating because you've asserted your right to remain silent and you've shut up. They can't use your shutting up against you, even to say you're being uncooperative. And you're certainly not being evasive if you're not answering at all. So those are the big takeaways. And, it sucks for Pink. She had this wasn't an unreasonable lawsuit for her to bring. It didn't have the best odds in the world, but it certainly had a potential for success. And it sucks that it didn't work out for her. Anyway, thanks for watching. Have a great day.